in our regulatory effort, a proposal that we posted requested comments on for the last 30 days. That comment period will close. It involved it involved an exemption for a particular type of 5.56 round. We've gotten nearly 90,000 comments. We will assess those comments and working with you, with others, see how we can really address what was at the genesis of that posting, which was an effort to address nearly 30 exemption requests and finding a framework for dealing with that.
I'll direct my first question to you, Mr. Jones. On February the 13th, the ATF released a proposed framework that would have eliminated the M855 green tip ammunition from the sporting purposes exemption. This week, ATF abandoned this proposal. A lot of us are troubled at the ATF's process and intent regarding this proposed ban. I've heard from numerous constituents who use this ammunition for shooting, sport, and hunting, and they're strongly opposed to the ban, as you know. Additionally, it's concerning to a lot of us that the new federal firearms regulation reference guide, published in January, inexplicably removed M855 ammunition from the exemption list for sporting purposes. Why did the ATF propose this M855 ban when such ammunition has been allowed under sporting purposes exemption for many, many years?
Well, Senator, thank you for the question. I think it's important for everyone to understand, again, that the genesis of us putting that framework proposal up for public comment was our good faith effort to try and construct a framework to deal with nearly 30 exemptions that we have had in the queue for many, many years at ATF. We do have a responsibility to regulate. We can't stick our head in the sand with respect to the additional exemption request. The M885 exemption has been in place for nearly 30 years. It was a classification that ATF made on that particular round, and I want to make sure everybody understands that this was not, contrary to some of the blogosphere, an effort to completely ban that certain type of cartridge. It's this one particular green tip that is, in essence, military surplus, that under LEOPA does qualify as armor piercing, but has had an exemption for 30 years and been in the market and used for sporting purposes for the last 30 years. And so our request for input on a framework was our effort to try and get a transparent process that we could act on the nearly 30 other exemptions that were there and not sort of not look at the exemption that was out there on M885. And so, you know, I think the reality of it is we need to deal with the pending exemptions. There aren't going to be any new exemptions granted until we work our way out through this. The exemption for M885 has been there for 30 years and will remain. And so, in essence,
and you abandoned it this week, did you not?
Well, we're going to take the input in. We are not going to move forward without analyzing the nearly 90,000 comments from all spectrums with a sense of figuring out how we do this rationally in a common sense way that first and foremost for us protects our law enforcement officers in compliance with LEOPA.
I wanted to follow up on some of the early questions regarding the work that ATF is doing surrounding following on the Law Enforcement Officers Protection Act. This was, just for the committee's recollection, a piece of legislation that was passed in 1986 by a 400 to 21 margin in the House of Representatives, passed by unanimous consent in the United States Senate, and President Reagan said upon signing it that there are, quote, certain forms of ammunition that have no legitimate sporting, recreational, or self-defense use and thus should be prohibited. This has always been tricky work to try to stay true to the Act's intention of stopping criminals from killing law enforcement officers with specifically dangerous type of weapons while also preserving the right of sportsmen and hunters to enjoy their pastime. But I just want to first thank the ATF. You mentioned in your prepared testimony for the amazing work that they did in and around the Sandy Hook shooting, but also just relay a story. I was in that firehouse mere hours after the shooting took place. And I had a law enforcement officer who was standing next to me remark that, in a way, he was glad that Adam Lanza took his own life because he feared for the life and the safety of his officers should a shootout have occurred, given the ammunition, given the power of the weapons that were found on Mr. Lanza's possession. And that speaks to why we passed this act in the first place. So I wanted to just maybe ask a follow-up question as to why we were considering this particular type of ammunition in the first place. It's my understanding that what has happened here over time, when we talk about these green tips, is that they were initially exempted in part because they were only used in rifles, but they now are able to be used in handguns. And we look at handguns in a different way, given that they are much more likely to be used in an assault on an officer. And in fact, the underlying legislation specifically references handguns as something that ATF should be looking at. So I think it would be helpful for us to understand why you got to the point of proposing that we take a new look at a type of ammunition that had been exempted, as you said, for a period of time. It's used in a different way today. That's the reason for the relook, correct?
Senator, I think it's important to remember that this 30-day period for public comment on a framework involves additional exemptions. The classification for that particular round, which is military surplus, which is 5.56, 62 grain, steel core, following into the parameters of LEOPA as armor piercing, was given, and it's had an exemption for 30 years. It's been on the market for that long. It's been available to folks for 30 years or more. I think the challenge for us, separate and apart from how do we grant exemptions going forward, and given recent experience that's probably not going to happen anytime soon, is the evolution of firearms technology and some of the platforms, assault rifle-based platforms that have evolved over those 30 years, and the capabilities of those and concealability of those. And in fact, some of them that would qualify as pistol platforms create some challenges for us. Now, I do believe that this is going to take work across the board, that this is not going to be something that ATF alone is going to do through a regulatory process. LEOPA is absolutely critical to officers' safety. I think everybody, if you're paying attention to sort of some of the challenges there, the handgun phenomena, the crime gun phenomena, primarily pistol phenomena, but as we see more and more of the firearms that could be classified as pistols being able to use not just this M855 round, but any 5.56 round, it's a challenge for officer safety, public safety. Bottom line, you know, you all have an opportunity maybe to have a discussion that we would gladly help you with on LEOPA, because it was passed in '86 and a lot's happened in the last 30 years.